He's the former federal prosecutor, now working the defense side of the table. You can hear him on London radio. I mentioned this in the first hour. You hear him. Everybody tries to get a piece of David Katz because his analysis is so keen. Fox 5 in New York, CBS in Los Angeles, and then everything in between. Yes, Katz in the house, says everybody. Katz in the house. How about it for David Katz?
Hi, it's great to be with you.
It is great to have you here. This is so apropos because he just did this moments ago, apparently. Donald Trump has, and I won't just talk about Trump, but I would like to start there. Obviously, there's a lot going on in these cases. But let me just ask you about a style thing that he does, because he's just done it, as I said. He just goes off on the judge and on the prosecutor, on the witch hunt, on the politics of it. I want to ask you a question about that working and its efficacy. How effective is that tear up the scenery kind of thing that Trump does?
Well, it seems to have worked for him. I mean, let's face it now. Of course, the political scientists all say it works with his base and the MAGA people, and it really turns off the suburbanites. Because, people have a good sense that, someone who's going to be the commander in chief and the leader of the free world ought to stick to the topic, ought to be focused. And he's obviously unfocused and scattered. And so I think that sensible people are kind of revolted by that aspect of him, as well as, of course, many other aspects of what I would call his really obnoxious personality. I was having dinner. This is a couple of years ago when he was still in the White House. And everybody at the dinner was conservative. I found myself there, and they were all saying, my God, the people elected a businessman. Why don't people like him? I said, well, let's start out. He's obnoxious. And they said, well, of course he's obnoxious, but people ought to take that in stride. And I thought, you're a politician, you're a glad hander. You want people to like you. You want them to have confidence in you. So I always thought that, that's why he's sort of a demagogue. He's sort of a person for this polarized time. Because, I think the argument for people, a lot of them who are in his base and why they vote for him in their heart, whether they tell a pollster or not, is that, they want only someone as obnoxious and scattered as him can stand up to the, quote, woke mob. I don't see the world that way at all, but I think that's a lot of what's going on. Now, regarding court, the judge is in a difficult situation. He has a lawyer. He has no legal right to add to what his lawyer has to say. The lawyer makes the closing argument, not the client. Everybody knows that. If you're in pro per, if you're representing yourself pro se, they tell you, look, you have to follow all the rules of a lawyer if you want to be your own lawyer. And then, of course, a lot of times those people acting as their own lawyers, those few, I think those foolhardy ones, are told by the judge, look, you have to obey the rules. You have to do this. They get held in contempt. They get told to stop. Now, the optics are, of course, very difficult with the cameras there and the world watching if he cuts him off because he plays into Trump's narrative. The judge didn't want to hear what I had to say. And the average person doesn't go through the analysis that I just did, Mark, and say, well, wait a second. You're trying to have your cake and eat it, too. You have a very skilled lawyer. I think this is the $3 million man who made the closing argument. So here's a real rich guy who can pay $3 million to his lawyers, but says, oh, the only way that I can have a proper closing argument is for me to go analyze the evidence. Well, no, it's not. He wants to give a stump speech. He wants to say just what he said. This is a victimless crime. Turning to that, Mark, it's not a victimless crime. You and I have talked about this. If you and I get together and we concoct a bunch of financial statements which aren't true to show that we're worth millions of dollars, and we then submit them to a bank, even though they say these are not audited statements, nevertheless, you and I would be signing them under penalty of perjury that they are true. If we get a bank to rely on them, the bank wants to have collateral if it turns out that the investment goes south. They don't want to find out later on that it was all inflated. We didn't own what we had. Now, let's take the case of New York City real estate, where these lenders apparently made money. The lender doesn't want to take a risk. It's not a casino. They want to have collateral. They want representations that are true about what it's worth. So the fact that these banks ended up not complaining very much, there are two reasons. Number one, they happened to make money. They'd have screamed like crazy if they'd have lost money, but they happened to make money even with the phonied up sheets, financial reports that Trump and the other defendants submitted. But on top of that, they're scared, like a lot of people, he might be president again. So how long and loud do you want to scream right now about a guy who might be president a year and can determine your financial future if you're those lenders? All nothing, all zero. And of course, this is the little speech that Trump gave, and he'll give those speeches outside. But does it work for him? Yes, I think it works for him with his base.
I love that you gave us that analysis, because I've heard and read this doesn't work. At some point, he reaches a point of diminishing returns on this. But and again, I'm just a layperson, obviously, but I think it is very effective. I think over time you believe it, but it was pointed out here in the chat, I think it was Spencer, said, why could Trump even speak? Wasn't he told that he wouldn't be speaking at closing arguments for all the reasons that you sort of outlined? You have an attorney, Mr. Trump, or President Trump. Why don't you just adhere to the rules of this courtroom? What he was just allowed to go off?
It's just the optics. I think a lot of people out there who are not legally trained and who haven't thought about it thinks, you're on trial, they want millions of dollars, why can't you say what you want to say? Especially, it's not a jury trial, it's just a judge. But the point is that the show is not for the courtroom. The show's not for the Court of Appeals. The Court of Appeals will think that this is a frivolous appellate argument, that not the $3 million lawyer that he hired to handle the case and to make the closing argument, but he himself ought to be allowed to get up there and add things. But the first, he told him when he was trying to do this by email, Trump was trying to seek permission. The judge told him, you can speak, but if you go off script, if you don't analyze the evidence, but you try to introduce new matters or completely irrelevant matters, or you make your stump speech, or you attack me and my staff, you do all the things that you're not allowed to do under this properly entered gag order. If you do those things, I'm going to escort you out of the courtroom, and I'm going to hold you in contempt and fine you at least $50,000. Trump didn't like the optics of being let out, right, by marshals. He likes to be the friend of law enforcement. The optic of marshals taking him out forcibly from a courtroom, he didn't like. He didn't like the $50,000 or more fine. So he played the game, right? He didn't agree to that. And then when he actually got there, the judge said to him, are you going to abide by the rules if I let you speak for 5 minutes? And Trump apparently just launched into what he wanted to say, that he was a victim. They ought to pay him. This is terrible. He's always the victim. He's always the victim. But, you got to remember a couple of things, Mark. This is the case where he said that his apartment was 3 times the size that it was. That's not an opinion. And after you hear that enough, these banks, they hear it, they see it on other forums. Should the bank have gone over there and actually measured the place? Should they have looked at the plans? They probably should have. And there's all kinds of reasons I won't get into why he might have gotten a very soft look at his financial records from that bank that he had this very suspicious relationship with. Putting all of that aside, this is not an opinion, Mark. You cannot say something is 3 times the size it is. You can't say that you have a property that's 2,000 square feet and it's, 500 square feet. And you do that over and over again. And, he did this thing where he said that the value of these things for the IRS is very low. I shouldn't have to pay any tax because, there's all these restrictions and I can't rent this stuff and it has environmental restrictions on it. But then when it came to these banks that he wanted to lend them billions of dollars, of course, it was incredibly valuable. He could rent each unit for $10,000 a month. He didn't mention the environmental restrictions. So he was absolutely gaming the system. There's really no doubt about that. And he sort of has this thing that, well, they shouldn't really believe my financial statements. They should have looked at me with much more scrutiny than they did. And of course, he managed, because of all that thing, being a TV star, this whole brand that he managed to, influence the public. This is how he rolled, and this is how he's still rolling.
It's interesting. And also, I think this is just Agolf says it's a chance for Donald to speak in court without risking perjury charges with his speech stuff. I suppose that on some level,
sworn in. Right, he wasn't sworn in. He was just, fulminating.
Yeah, except fulminating is such a ding word. God, nice job. Now, David, then to the question of immunity. I wonder if you could speak about this situation and the. Is it an interlocutory kind of part of where the judges ask questions of the attorneys? Is that I don't know what that's called, but where you can tell something based on the questions, sort of like, it seems like the judge is sort of skeptical of this.
Yeah, I think that the 3 judges are very skeptical. I think it's good that one of them is a Republican, and I think that all 3 of them are going to say that. What do they say in the South? this dog won't hunt. And the reason that this dog won't hunt is because if you think about the implications for what the president could do, the idea that you have to be impeached and convicted in the Senate first before you can be prosecuted for anything really does logically raise the specter that they're about to impeach a president and he shoots or has shot one of the senators or one of the House managers. And the argument is, well, you can't be prosecuted even for that until after you've been impeached and convicted. Who in their right mind, right? This is what they do in third world countries. I don't lightly compare him to Hitler or something like that, but if you were a deputy under Hitler and you started to bring a motion against Hitler, you were tortured and disappeared, right? It's totally against our democracy and our rule of law that someone could be tortured, disappeared, a political enemy of the president, okay? But and so I think that the ruling is going to be fine. I think this is going to be fine. I think that the U.S. Supreme Court is then going to stay away from it. And maybe what they'll say is that after the trial, depending how things come in, if the evidence ends up showing that everything he was doing was in the course and scope of his duties, if it was in what the courts have called the outer perimeter of the course and scope of his duties, that he can bring that up on appeal and maybe have the case thrown out after an appeal if he's convicted. But I think they're maybe focused on this idea of, can you stop your trial? Can you do what you call an interlocutory appeal? Now, the argument goes like this, Mark. You have the right under double jeopardy, which the double jeopardy thing here is frivolous, but you have a right under true double jeopardy not to be put in jeopardy twice. That means you have a right not to have your second trial start if it really is a double jeopardy trial. He's arguing the same thing under presidential immunity, that he has a right not to have that trial ever start if he's truly immune. What's the point of immunity if they drag you through a trial? And the only case that the Trump side really has, they have all these blowhard arguments and crazy things that they say, like what I just said. Could they really go plant evidence on a political opponent and then you couldn't go to trial on that unless you were impeached and convicted? And how does that work with a former president? Because how do you impeach? They're really going to have impeachment and conviction of a former president? I mean, think about it. Doesn't Congress and the Senate have something else to do besides go and impeach a former president before Jack Smith can prosecute him for things that he did while he was president? But the troubling case, I mentioned it to you before, is this Nixon versus Fitzgerald. It's from the Nixon era. Remember this, though. Nixon was much more disgraced in the eyes of the law and the public than Trump is. Nixon was not running for re-election at that time. He was not running for any public office. So here's a disgraced person. And even with that, 5-4, the U.S. Supreme Court said he didn't have to face any kind of civil trial or civil judgment. If the U.S. Supreme Court wants to take this and they want to have 5 or 6 justices on their side, they can say, hey, you guys are all talking about Dobbs. We didn't follow precedent of Roe v. Wade. Here we are following precedent. We're following Nixon v. Fitzgerald. That said that a former president cannot be tried civilly, and we're just saying that a former president can't be tried criminally. Now, there is a difference.
But that's a huge difference, David, right? Civil and criminal.
The idea, people say the greatest thing about America is that any pauper can sue any prince. And they say the worst thing about America is that any pauper could sue any prince. In other words, the idea is anybody can file a lawsuit against anyone. There's summary judgment, there's cases, that get dismissed, but anybody can sue anybody. So the Supreme Court 5-4 may have been thinking, anybody could sue anybody. You can't have a former president harassed for the rest of his or her life by having lawsuit after lawsuit. But criminal, they could say, if they reach this far, reach the merits of this, they could say, you know what, criminal is different because still you have to have a prosecutor decide to prosecute somebody. It's not just like anybody files a civil lawsuit. But if I can stay on Fitzgerald for a minute, it's a very scary case because the 4 dissenters in that case, where they were Marshall and Brennan, the 2 famous liberals. They were also Blackmun, the one who wrote Roe v. Wade, even though he was a Republican appointee by Nixon. And also a fascinating justice I won't get into named Whizzer White, who was appointed by JFK. The 4 of them dissented, and they said, look, if we are saying this, if we are letting a president do things, a former president, get away with things like this and not be sued, we're really saying that he can get away with things like this and not be prosecuted. The four dissenters said it right there that the logical extension of what the majority were ruling, was that a president could not be prosecuted. I'll say one last thing about Fitzgerald. Fitzgerald was an egregious case. It wasn't just somebody suing former President Nixon over something. Fitzgerald had testified as a whistleblower in Congress. Everyone agreed he told the truth, that they had overvalued this plane by about $2 billion. Obviously, Nixon and his friends were in favor of the plane, and they wanted to get back at the guy who'd blown the whistle in Congress, truthfully, that the plane was $2 billion more expensive than the record showed. The discovery showed that Nixon and his minions had absolutely targeted this guy, gotten him fired, ruined his career, despite the civil service protections that he had. With all of that evidence, former President Nixon in disgrace, they ruled that he could not be sued. That's the one precedent that I'm scared about, but I still think, hold your breath, everybody, okay, breathe, that there's not going to say there's a presidential immunity, at least not one that kicks in at this stage and that stops this trial further. So I think early March, that trial in Washington, D.C., for all of the bad acts connected with the insurrection leading up to it, the slates, the obstruction of justice against Trump, I think right now it looks like it's on track. They may be picking a jury starting in March.
Wow. Wow. What a great summary of the law. They can rest a judgment in favor of the presidency, in this case, Trump, that they can rest that on. What a great summary of that.
Can I say one last thing, Mark? Mark, can I say one last thing?
Yeah.
They analogized it, the majority. Four of them were Nixon appointees, for people who like that sort of thing, who ruled in favor of disgraced Nixon. But the five said, judges and prosecutors have immunity. If a judge, quote, railroaded you, but did it from the bench, let's say you could prove that the federal judge had found you guilty when you should have been found not guilty, didn't suppress evidence because the judge just had a personal animus towards you. They said you can't sue the judge or the prosecutor in that situation. Now, there's a lot of people who think that may really not be the law anymore. If a prosecutor's out to get you, and you can prove the prosecutor's out to get you, you know what I mean? You're dating his old lady, right? And so the prosecutor wants to get you for a personal vengeance reason like that. I'm not so sure that you can't sue the prosecutor, or you couldn't sue the judge on those facts. But they analogized it, and the dissenter said, at least you have to do it by functions. You can't do it by the office. The president shouldn't be any different from a judge or a prosecutor. It's the function. And that's the thing. That's the function, the outer perimeter of the function. And so this idea that you could give the State of a Union address and say that that was your function, but in the State of a Union address, in front of Congress, the president would say, I want you to kill my opponent, Mr. X. I think that they would say that the functionality of that, you can't hide that threat in the fact that it was the State of the Union. Having said that, Nixon was allowed not to be sued, and he went after that guy. He went after that guy in a way that he said it was an administrative personnel decision, but it was to get that guy because he told the truth in front of Congress in a way that Nixon didn't like, and they could prove that in discovery. Anyway, I do think they're going to win, Mark.
But that parallel is just so perfect because, we've seen that same kind of thing from the former President Trump times whatever. I mean, you look at that guy who testified before Congress. I mean, that seems sort of analogous to the about the Ukraine call I'm talking about. That seems sort of analogous to the Nixon situation. But this is obviously that upped to in any way suggest that there's a shield of immunity around the executive office. Wow, it's that's sobering, though, that case to which you've referred. I want to take you away from Trump for a second and ask you about a gun ruling here in California. There's a new California law that's barring licensed gun holders from carrying firearms in many public places, and it's being blocked. This law is being blocked. In other words, the law would have barred, again, gun holders from carrying their firearms in a lot of these places. That's being blocked because it's being appealed in federal court. I wonder if you could speak to that ruling, that appeal, and what happens in the interim. Just handicap that for me, please.
people, I think this one is going to come out all right. I think ultimately California's ban is going to be upheld. I don't think that the New York pistol case, which was a 6-3 decision, they even got Chief Justice Roberts on that one. It's a 6-3 decision, but I thought that case was more cautious in expanding Second Amendment rights than what the Ninth Circuit is doing here. This is sort of like the federal court's course, but I'll make it as succinct as I can. The reason it's confusing is that once California's ban, and basically the ban affects even people with gun licenses. So someone has gone through the vetting process of getting a gun permit. Okay, if you don't have a gun permit, this doesn't affect you. But if you do have a gun permit, there are still, under the California ban that went into effect January 1st, places you can't go. And a lot of them are very logical places that you can't go. You can't go into a place that serves alcohol. You can't go to Dodger Stadium, right? You can't go to, a school. You obviously can't go to a courthouse and other places like that. By the way, if the judges keep bans on locations, believe me, they'll keep bans on the courthouses. Just saying. But this ban was then blocked by a very well-respected U.S. district judge down in Orange County. And he said, look, I think that this ban is inconsistent with what the U.S. Supreme Court held 6-3 in the New York pistol case. It went up to be stayed, and one of the appellate panels on the Ninth Circuit, that's the federal appellate court that covers the entire West Coast, one panel said, well, wait a second, let's not put that injunction in place. Let's let the law go into effect, let the ban happen. So the ban did go into effect. Now another panel, which apparently looked at the merits more, said, well, wait a second, it really is covered, we think that the plaintiffs have a good chance of winning, so they let the ban, they took the ban out of effect again. So it's very confusing. Right now, the ban, passed by California voters, is not in effect. A person with a gun license, a gun permit in California can go into Dodger Stadium, opening day. They can go into bars, they can go to churches, they can go to other places where the California legislature decided that even if you have a gun permit, you should not be allowed to go. The argument by the gun owners is that what's the point of having a gun permit? It's so I can have self-protection. My enemies can just wait to attack me, or the high crime, the people who, the criminals will attack me exactly in those places. I'll get mugged in the parking lot at Dodger Stadium and I'll be helpless. Even though I have a gun license, I won't have my gun with me. Some of those places have a lot of checking, and so you wouldn't be allowed to take the gun into Dodger Stadium. People would know you were unarmed there. That's their argument. That
Sure.
Second Amendment allows his self-protection. It allows you to not only, keep arms at home or in your office, but bear arms, to carry them around concealed in California if you have this gun permit. But these are places where right now, persons with a permit can still take it. The reason I don't think that it's ultimately going to be upheld, I think that the ban will go into effect. We will have the ban, and these people will be banned from taking their guns, even with a permit, into these sensitive places, is that the U.S. Supreme Court talked about those sensitive places. And I got the feeling from the U.S. Supreme Court that the problem in New York was that they wouldn't issue you a permit. It was so hard to have a permit issued. But in the course of that, my recollection is they said that's a different question from where even a person with a permit can take the gun. And I thought they mentioned bars and Yankee Stadium as places you couldn't take a gun. And if my recollection is correct, I think that
that tips their hand. Yeah, that tips their hand. David, we're out of time. Can I just give me 45 seconds on that Alaska Airlines flight? The emergency door, it's called a plug, blah, 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 popped out. It, at 16,000 feet, a bunch of stuff was sucked out. Nobody themselves was sucked out, but apparently it was quite a violent event. Others like it. United Airlines just landing, but without the plug falling out. My question is this. If I wanted to take our next guest, Belinda Weymouth and I were flying somewhere, and we had this happen, and we were both traumatized by it. We needed therapy. We wouldn't want to go on a plane again. We legitimately had emotional damage done to us as a result of this event. Could we bring a lawsuit against United or Alaska or Boeing, or might that be possible on a class action basis even?
The airlines have gotten a lot of protections, and so you can't sue the airlines on the same theories that you could sue, let's say I were driving you around, right? And my car was so defective that the door blew out and you were traumatized, maybe in the same way. We were up in the mountains. We went down a scary road. You and Belinda were traumatized, okay? You can't sue the airlines under exactly the same conditions, but certainly you could sue them individually. Belinda could sue them. You could also, some lawyer would probably contact you and try to get you as part of a class. You know, the problem in some of those class actions is that there's fairly minimal damages for each person, and they get criticized because the lawyers make so much money and each class participant gets so little money. But this is one where you would really show your trauma. It might not be a good class action because each person suffered a different kind of trauma. You sat closer to the door. You know, there's a person whose the impact was so great of the wind, his shirt blew off of him. Someone else, their cell phone blew out because whoosh, luckily they were at 16,000 and not at high cruising altitude.
But you're saying that you could actually nibble around a court case.
Oh, sure. Oh, people are nibbling, I bet, right now. I bet the class action.
There's some nibbling going on even while we're speaking.
The kings and queens of class action are contacting potential members of the class as we speak, Mark. It's so great
David,
to be with you. By the way, a shout out to Kim.
Kim, what out? What out with where did Kim go away? What happened to Kim? She's
Well, she doesn't have to be here to have my happy New Year and all the best to her and all of you.
There's
Kim. How are you?
There's Kim. Okay. He was just giving you a shout out, Kim. All right.
I love you. Thank you for coming.
Great to be on the show.
I think David likes Kim more than he likes me. I don't mean
No.
I grew up with a really smart sister, super smart. She speaks like 4 languages fluently. She has 3 degrees.
Wow.
She grabbed top of her class at Stanford Law, blah, blah, blah. I grew up with that kid, and I know that my parents liked her more than me. I know it. I mean, it's not like and now I'm starting to get that same feeling from David Katz that he likes Kim. Yeah,
you know what they said about the baseball catcher who spoke 10 languages, but he couldn't catch in any of them.
David Katz, thanks, David. Woohoo! Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.